Good evening, everybody, and welcome to another Wednesday webinar with Property Law Alliance. I'm so sorry that we started a bit late. We've run into some technical difficulties. And I think in the beginning of this video, you saw me glitch as well. So I was like, oh, we're live. So apologies for all of that. Seems to be just one of those Wednesdays. But as always, it's so great to have you with us, the viewers, as well as our experts, Cilna and Bruno. How are you doing, Cilna?
Very good. Not an IT expert, definitely, but evictions, rentals, lacquer, but clearly IT is not my strong suit, so I'm sorry.
Bruno, how are you doing?
No, I'm good. Good. Still at the office. Gonna be here for quite some time. So yeah, as good as can be.
Doing what you guys are doing, what you do best, I suppose. Doing what you do best. So we're going to start today's session off promptly. Firstly, because we did start a little bit late, and secondly, because we have a nice, a whole lot of host of questions that we're going to pose towards Bruno and Cilna. We're going to try and do it in a quick fire manner if we can. So let me get straight into the first question, and I'm going to direct this one towards Cilna. And the question is, can an individual buy a property under a business that's new if they are married in community of property? And then secondly, what are the requirements if you're married in community of property or out of community of property? How would it work? What does one need to do?
That's a good question. Thanks, Chris. A very good question. I think irrelevant to the question, and that's why I'm going to start with that. I'll break him up in little pieces. Irrelevant is a new company or an old company to the question. You can buy a property into any company. It doesn't matter how old it is. So just a quick side note on that. In the old days, where it took a very long time to register a company or a closed corporation, a CC, people used to buy shelf companies because there was, it just took long, and people thought if you have an older registration number, your company seems more secure or something like that. These days, because you can register a company online, there's really no reason to buy a shelf company. And the age of a company is irrelevant, because if your financials doesn't coincide with your registration number, it's irrelevant. Because I mean, if your company was registered 12 years ago, but you had zero financials for 12 years, it's as good as a brand new company. The risks of shelf companies are pretty high simply because you don't know the history of the company. So just a quick side note. The reason why there could be a thing about a new company or an existing company is if you want to buy a property and the property has to be bonded, so you're reliant on bond finance to buy the property, a brand new company with zero assets, zero trading value, zero anything, obviously the bank is going to be like, what? No, we're not going to give you a bond. But that's the only thing that's relevant. I definitely always recommend buying property into a company. You can deal with the company much easier. You can transfer the shares to a family trust. You can sell the shares of a company instead of selling the property. Still, net effect is the same. You're still going to pay transfer duty, but you have much more agility in a company than in your personal capacity. And obviously, if you bought in your personal capacity and you transfer to a company, even though it's your company, you're still going to end up paying transfer duty as well as transfer costs. So it could be an expensive thing. But back to the question, definitely you're allowed to transfer a property into a company, buy a property into a company. If you're married in community of property, anytime you are placing a burden of sorts on your joint estate, you need consent from your spouse. Now, to buy a property is an asset to your joint estate. It doesn't place a burden on it unless you are using the money from the joint estate. Then it is. Then definitely you need spousal consent. But if you have one company and the money is separate, and it's completely, it was money that you inherited that was specifically excluded from a joint estate, and you want to use that money to buy a property into a company, in that circumstance, you can definitely skip spousal consent. But if you are using money from the joint estate, you are buying something that's going to place a burden on the joint estate, definitely spousal consent. On this, I just want to make a quick side note here. If you are married in community of property, to rent a property or to rent a property out, so whether you're the landlord or the tenant, is specifically excluded from the Matrimonial Properties Act. So there's no requirement when you're doing a rental to have spousal consent. If you are married in community of property, whether you're buying the property into a company or into your personal capacity, so into the joint estate, has zero effect. The question is, are you going to place a burden on the joint estate? When the answer is yes, then definitely you do need spousal consent. Did I answer all the parts of that question, Bruno?
I believe you did.
That quick, like 4
Nice.
minutes.
So,
Quick fire. That's what we're doing tonight. Quick fire.
Just on that one, just on that one, let me just a couple of comments on this, things that I've also noticed in practice now. Matrimonial property regime becomes a massive problem when it comes to planning out your estate, doing proper, like anything financial, tax planning, you name it, right? The problem is that people don't realize the implications of getting married in community of property as they get into the marriage. And the reason for this, obviously, is they assume that the status quo, the position that's automatic, is the correct position, and anything aside from that might be unfair towards the parties or overly complex. The problem with this is, in the world that we live in, the in community of property marital regime causes a massive issue, because effectively it pulls all the assets together into one joint estate, one pool, like Cilna mentioned. And this has huge exposure between the parties, because anything that happens to one technically happens to the other, because everything is combined. So the issue now with obtaining finance is exactly that. How do you go off and obtain finance when now you need to rely on your spouse's financials in the same breath, or the financials rather of the joint estate? So from a financial planning perspective, it's very important to remember that getting married with a proper marital regime, something out of community of property, with or without accrual, is essential. And this does not necessarily mean that you or your spouses are going to screw each other over, because remember that when you can replicate a in community of property like regime, getting married outside of community of property with accrual. The only difference is that your creditors won't have access to this joint estate. Ultimately, when you divorce or when you pass away, the accrual will be separated, and both parties will basically benefit from the growth of this estate during the course of the marriage. But at the very least, from an asset protection perspective, you're not allowing your creditors access to this joint estate. Each of you actually has their own separate estate, and they can actually run things in their estates as they deem necessary. You also don't need spousal consent for most of the things that you're going to be doing within this. If you are married in community of property, strong suggestion, try change it. There are ways of doing it through applications to the court. If you really can't do it, I have structured certain trusts as vehicles where you replicate that, but you actually try and do it in the trust as opposed to in your personal name, and you start creating an environment in the trust that kind of deals with it. And at least in your personal capacity, you've got slightly less exposure. But yeah, it's just to kind of top up what Cilna was saying.
Sounds good. And from what I'm getting from you, both of you, is that if I marry an old, rich woman, I've got to do it in community of property, and I got to do it fast, like right now. Okay, I got you.
That's the answer.
Let's move on to the next question.
You've got it, Chris. Will you still host us though?
All the time. Here we go. Here's the next question. Can I hold the body corporate where I live responsible for my insurance access if my car or home has been broken into? And this is if the body corporate has failed to secure the complex. So this would be in the sense that they switched off electric fencing because they believe it to be too expensive. A gate motor breaks and they don't replace it because they're like, nah, we just don't want to do it. And then my home or car gets broken into. Can I hold them, liable for my insurance access, or for any payments for that matter that I need to make? Sorry, Bruno, that's you. Yeah. Sorry about that.
Okay, look, so it's not a very common question. So to begin with, there will probably be some gray areas here and a level of debate and different considerations. The facts will also play an integral role in actual determination on whether there is liability or not. So if we take it a step back and try look at it from the beginning or from the outset, the responsibility of the body corporate is to follow the instructions of the owners, right? Through the appointment of a board of trustees who are supposed to act in the interests and in the care of the owners within that estate. So there is a duty to act accordingly, right? You wouldn't intentionally do something that goes against the wishes of the estate, knowing that it goes against the wishes of all the owners. So typically, off the back of that, you're probably already looking at a breach of the duties by the trustees in not having informed the owners that there is a risk of security breaches, knowing very well this isn't a country where we are surprised when crime happens. So there is an expectation, or not rather expectation, but the realization that crime will happen and you need to take steps against it. So in a situation like this, I would say that it is a breach not to inform the owners of the risk, to allow the situation to persist, depending on the length of time. So, for example, if it was an overnight issue and it was a mistake, maybe it's excusable that they couldn't go and contact all the owners. But if it's been persisting for a period of time, I would say that there is a level of negligence there, or at least a breach of a duty. And there would be some responsibility to compensate the owners if it can be proved that the crime happened because of that. The other thing that you need to remember also is crime happens. So the reality is that it could have happened anyway. So we need to be mindful of the fact that, you can't blame someone, for example, simply because one small little thing happened and the crime was committed and now it's all their fault. But in a case like this, where it looks like the security infrastructure was down, I'd probably say that there's a good chance of liability.
Sure. Cilna, do you want to add anything onto that quick fire, or are we good to go for the next one?
No, I think we're good. I think the important thing to note, though, is it's not as long as the body corporate agrees to something. So say, for instance, there was a meeting, there was a special general meeting, and the majority decided, it's okay, let's turn off the gate motor, let's turn off the fencing. And even though this owner might not have been at that particular meeting, if the body corporate then decides to do that jointly, and that becomes a rule, and that is the decision made, and there's a resolution to that effect, then definitely not. So I think it's important always to realize how the law works is there's 3 rules and 59 exceptions to it. So I agree with Bruno 100%. I just don't want the perception to be that if there is something, because the body corporate, just go make sure that you've actually that you read the minutes of the last AGM and HGMs before you start causing chaos in your body corporate.
Yeah.
And attend your meetings. Attend the
Yes.
meeting, because people tend to, in body corporates, not attend the meetings, and then unfortunately have direct impact on them, but they never attended the meeting. That was me. Okay, now I'll keep quiet.
Thank you both. I'm going to go quickly to the next question. This is a fairly lengthy question, so please bear with me, but it's very interesting. It says, I have signed an offer to purchase in December for a unit in a block of flats. I paid the deposit and some of the bond fees. The contract stated that the estimated date of completion is June 2021, but problems have started when the actual construction had not commenced and still not commenced. I called the attorneys as well as the developer, and I could not get an answer as to when, the construction would start. So I then told them, look, I want out of this. I need out. And they've then told me that there's going to be some penalties. I may need to pay the commission for the agents. And I just want to know, do I need to wait forever for construction to start? I mean, surely I've contracted for them, to start on a specific date. I've also made arrangements in my personal life that have now impacted me because the construction's not started. So the question is, am I in breach here if I want to pull out of this? And what is the reasonable period for an estimated date of completion, for this kind of project? And do I have to then wait indefinitely? So I'll quickly throw this one to Cilna, and then Bruno, you can jump in on it as well.
Very good question, and I think we've seen this quite a few times. The scary part, and sometimes I am known for my ability to call a spade a spade. Usually, people read contracts only when there's a problem. The content of this particular OTP will be the only thing that can guide you. Obviously, you're not allowed to contract on something that is against good morals. So, contra boni mores. So, say for instance, there's a term in the OTP that says you are paying 50% of the purchase price on signature of the OTP. If the developer never gets to the development, after 3 years, you will forfeit your full deposit. That is against good morals. That's against so many pieces of legislation. I can't even, I won't bore us with that. But something like that is unjust. But at the same time, if a developer advertises a development and you're buying off plan, you must appreciate the risks that you are accepting. So you are getting a lot of benefit. You can choose, in most cases, the fittings. So you choose the tiles, you choose the specific countertops and stuff in the kitchens. So you have a lot of benefit, but your risk is usually that there will be a clause, and I really would like this particular viewer to go have a look at your OTP, read it, with the eyes not to find the answer you are looking for, but read it with objective eyes before you go to an attorney with this. Because the truth is, attorneys, as cool as we are, we can only apply the law. We are not magicians. We can interpret your contract, but we can't change what you've agreed to during later parts of last year. If the contract says that the developer would be indemnified against any claim from a purchaser, should there be a delay in commencement of construction, there should typically be a time period or some of the other sort of element that doesn't leave it open-ended. If it is left open-ended, please go see an attorney, ideally a property law specialist attorney, to help you with that, because that's not supposed to be open-ended forever. But you are always allowed, and I would be very surprised if you sign an off-plan purchase OTP without any safeguard for the developer to not commence on commencement date. I have seen so many developments. We're all excited, and it's always the attorneys are out there, everybody's out there, and it's this vacant piece of land, and we always say, okay, so we are going to break ground by the 1st of June or the 1st of October. Everybody's into it, everybody's excited, but as you stand there and you're excited about it, we all know, a million things can happen, and it could be delayed. And especially currently, I don't want to blame stuff on COVID, but this constant, you put your left foot in, you put your left foot out situation, level 3, level 1, level 4, level 2, level 1.1, level version 2.0. Nobody knows exactly what's going to happen. It does impact construction more than many other industries. So that is also a potential defense of Simao. If the developer is really not able to commence construction because of that, definitely a valid defense. But the answer will always lie in your OTP. You would be entitled to cancel your OTP on certain conditions. Typically, in a case like this, where your construction doesn't commence, your typical course of action would be to send a letter of demand to the developer if he is in fact in breach of the agreement. So if he had to start building on day X and he had 3 months allowance to delay and he didn't do anything about it, you would typically be allowed to place him on terms, give him a certain time period, which will be in terms of the OTP. Nothing that happens in an OTP, how long notice you must give, when they must start, how it must work, happens outside of the offer to purchase. All the answers that you are looking for, I promise you, is in your OTP. Once again, if it's not, then I'm a little concerned, but give him the time period allowed in terms of the OTP when he's in breach of the agreement. Then you are allowed to either approach cancel the agreement, and you might be liable for a cancellation penalty, very much. If the agreement allows for instance, a roadweb sort of agreement, something like that, or a forfeit, a deposit that you may forfeit, it would be allowed. However, if it's on the back of the breach of the developer, typically not. Then your cancellation will go with a damages claim against the developer, or you have another option, approach the High Court for a specific performance order, compel the developer to commence construction. That's very often a fun one. But on the other hand, courts are very reluctant to force something, for instance, like a sale on a purchaser or commencement of construction on a developer, simply because very often a specific performance order, if the court sees that this particular fact does not allow for a specific performance order, so in other words, the party that is now compelled by court to do something physically can't do it, there's some form of impossibility, then you will fall back on cancellation with a potential damages claim. That was a very long answer.
Okay, so quickly from my side, just two situations, nice experiences. First of all, I can't remember the first one, damn it. So second one, let's just skip through the first one altogether. The vis major argument or the COVID argument. Very recently, I had a very similar situation where my client was the developer, but there was a level of subcontracting to other contractors. And what happened over there is the difference in contracts, the difference in contracts is that obviously building contracts carry certain penalties, clauses, typically timelines and the like. And what happened here was there was a certain timeline set, but it made provision for variations based on conditions that were beyond people's control. Be very careful when people start using COVID, because you actually need to be quite precise. So in this particular instance, there was an issue in the steel industry with the supply of certain steel products, and blaming the delay on this, when in fact it only caused a 3-week delay, but the contract was delayed by over 2 months, is not justified. So unfortunately, you do need to get into the details when it comes to situations like that. Point number one that I was going to raise is if the contract is silent on time periods, there are principles in our law regarding what a reasonable time would be. Now, obviously, these are open to interpretation. It's very grave because one person's reasonable is not another's. But I had this very similar case to this about 2 years back. And I think in that instance, 1.5 years had gone by and building hadn't started. Now, the reality is that is completely unreasonable. Let's be fair. And because of that, it's pretty straightforward to be able to write the letter, allege the breach, even if the contract doesn't necessarily have very precise ways of doing that, because it is a breach ultimately, based on what's reasonable. Sure, they can argue that, they can argue whatever they want to argue, but if a long enough time period has gone by, you can rely on the fact that time wasn't, that the delay wasn't reasonable.
Thank you, Bruno. Thank you, Cilna, for that. Now we've got a little bit of time left. I've got 3 quick fire questions. I'm going to pose the first one to Bruno, second one to Cilna, and then third one to Bruno. And
so 1 minute answer.
This is a challenge. There you go. 1 minute answers, right? There you go.
Okay,
so the first one is, this question was asked by a gentleman by the name of Samuel Sitole, and he says, when refinancing a property with a higher than the initial bond loan amount, are attorneys still needed for the process of bond refinance? Bruno.
Yes, they are. So what actually happens with mortgage bonds is initially, if you make provision for a higher mortgage bond amount and when you first apply for a loan, you wouldn't actually need the attorney the second time round because the bank just increases the finance up to the amount that the mortgage was registered for. But if you didn't do that the first time, the attorneys do need to go to the deeds office, increase the bond in order to fit what the new loan amount will be. Bam.
Bam. That's beautiful.
Listen, second, now Cilna, it's your turn. We gotta go. Second question. Can you transfer the property into a company, even if you bought the property as a natural person and you're still owing the bank? Can you do that? I'm not sure if I'm clear in this question.
Yeah,
but you've got a money.
You can, but the thing is, then you need to make sure that the company that you're transferring it to will qualify for a bond as well. So if you own a property in your personal capacity and it is bonded and there is an amount outstanding on that, you can't sell it for a different price and you have to repay the bank before you can cancel the bond, and you have to cancel the bond before you can transfer the property. So yes, you can, but then you need to finance the sale in terms of the company. I swear I was quicker than Bruno there, but okay, my question was quicker.
Okay, now we've got a third question, and you're both going to answer this. I want 30 seconds. You can do this. So we're going to start with quickly, Cilna. Here we go. In an offer to purchase, well, let's start with Bruno. Sorry, let's be fair, right? In an offer to purchase, can the buyer add a clause that will withhold a certain percentage of money upon transfer of property if there are pending documents that the seller promised to give the buyer?
Yes.
Yes. That was less than 10 seconds for both. Yes.
Brilliant. Absolutely brilliant. Oh, guys, thank you so much. That's literally all the questions we have for today. It's so fun to have this quick fire session questions. As always, it's good to have you, the viewers, with us. Please do post your questions in the group. You can post them in the comments below, or you can go to the group, and there's a whole host of videos that we want you guys to watch as well on a whole host of topics that our experts have dealt with. So please go there, ask your questions, and join us next week, Wednesday at 6 o'clock. As always, thank you, Cilna.
Thank you so much. It was so much fun. Sorry for my very entertaining background tonight. I had a very active family tonight, but I suppose as much as we love law, we love our families.
Thanks, Cilna. Thank you, Bruno.
Thanks, guys.
Thanks, guys. Cheers.
Thank you. Bye-bye.